How would you manage if the business moves from one state to another while an E2 managerial employee COS is pending? Is this material change that could affect the case? The company is incredibly successful both financially and with hiring
Yeah.
USC LPR.
Okay. Great question. Great question. So, usually a relocation into a different state could be seen as a material change. Of course, in over the years, I had clients that they did it without telling me. So when we apply renewal, I'm kind of sweating bullets because I know that could be perceived as a material change, but we got an approval anyways. That was with the consulate. They tend to be more lenient on that kind of stuff, but I wouldn't push the envelope with that. So with a relocation change, if it's a lock and stock complete move to a different state, I'm going to err on the side of caution and treat that as a material change and advise the client you need to apply for an amended E2 ASAP to avoid the risk of denial for failure to maintain status. Um, I think the question is making the relocation while COS is pending. I never like and I never recommend major business changes while a E2 is pending. Here's why. They're making a decision based on the facts presented in the petition to the USCIS or to the consulate. If there are significant change, we are obligated to inform the USCIS and the embassy of the significant change because the basis for which we're seeking E2 qualification has changed. They need to factor that into their decision. So whenever you have this kind of change and you need to interfile, affirmatively inform them, you don't know if your documents are going to reach the file with the USCIS. I've done interfile before and it's hit and miss because you're not responding to an RFE, you're affirmatively notifying them. And you don't know if it's going to get there. They could adjudicate it based on the old facts. So I tell a client, please try to hold off. Maybe we'll do premium processing, get a faster decision, hold off on the change. And with the change, if it's a lock and stock move to a different state, I would interpret that as a significant material change. If it's like an expansion where you're keeping a presence in the original location that you presented to the immigration authorities, but you're just expanding into an additional location, I would be more comfortable treating that as a non-material change where it would be palatable to explain at the time of renewal extension. But making significant business change while an extension or COS is pending, or even consular application is pending, is a complicating factor. And then you can have the client, if consular, you can have the client bring the evidence, new evidence to the interview. But then the thing is, now you're risking potential delay to the decision because officers thinking, I need to review this. I haven't had a chance to review this, or you pre-submit it to the embassy. But with the USCIS, the interfile process, it's hit and miss, and I don't recommend it. So if it's possible, I would advise the client to hold off on that until we get until you get an approval. That would be the safer way. Yeah, and it's also like when you renew the E2 in the future, and they see that the change occurred, even if you get it approved based on the facts asserted before the change, and you apply for the extension in the future, and they notice the timing that you made a change while the prior COS was pending, and you did not inform the adjudicator of the change, and they approved it based on inaccurate facts, that could impact future extension approvals as well. So I would, advise the client try to hold off if possible.